Hi, thank you for tuning in. Welcome to the It's Your Money and It's Your Estate workshop series brought to you by our nonprofit organization, Financial and Estate Literacy. Our mission is to empower people like you to take control of their finances, their estate, and charitable giving decisions. For the past 25 years, our founder, Peter Kote, and our entire team have been providing these free, unbiased, and accessible 6 weeks programs all over Orange County, California to help you make informed choices that align with your unique needs and values. Now let's start the program. This webinar is the third session of the It's Your Estate program. The topic is wills and trusts. Our guest speaker is Julie Cho, our moderator, Peter Cote, and this webinar is brought to you by American Heart Association. Enjoy the workshop.
Julie, come on up. Thank you for being the presenter today. Julie, Let's talk a little bit about you.
Okay.
How long have you been an estate planning attorney?
I've been an attorney for 27 years.
27 years.
Yes, and specifically for estate planning, I've been doing it for about 17 years, I think. Good enough time.
The years go together, don't they?
Yes, they do. Yes.
But why is it important for someone to know how many years have you spent focused on estate planning?
Well, it's a matter of expertise, right? Every area of law, as well as, for example, every area of medicine, there's different specialties, and you want to keep up to date on the current laws and the changes in whatever field it is that you're practicing, or if you're the client who you're seeking out for expert opinion. And estate law especially is just ever changing and constantly you need to keep
court cases, come down, and you need to be aware of those court cases.
That's right. So that's why I like to just specialize in estate planning. I don't do immigration and family law and estate planning all under one shingle, right? I just do estate planning. So
that's the way you want it.
Yes. Stay in my lane.
Yeah, exactly. Okay. You're registered with the Bar Association here in California. And why is that important? I mean, can you practice law in Nevada, Washington, New York?
You can only practice law in the state where you're licensed. So to be licensed in that state, most of the states require you to take what's called the bar exam. And some states will have reciprocity, like if you're licensed in one state, then you can go practice in another. But for the most part, you need to take the exam here. Yeah. So why that's important is because in order to practice law, so that means to give legal advice, you need to be licensed in that state to give legal advice on that state's laws.
Yeah. And if a person comes into you and has property, for example, in another state, and they have issues that they need legal help on it with that property, what do you do?
If it's dealing with the laws of that particular state, then I will refer them out to another local attorney in their area. So I do have a network of, part of a group of attorneys where we can refer our clients out to others in different areas.
Yeah, we're going to get into this probably in the session, but it's almost a slam dunk if somebody has property in another state that they need a living trust.
Yes, right. So if you just own property in another state, but you have a California trust, I can transfer that property into the California trust to make sure it doesn't go into probate, because that's just it's a title transfer. But let's say you've got property there and you need to evict a tenant and you need to open up an eviction case, then that I would refer out.
Yeah. And the last thing you want is multiple probates in many different states,
Absolutely.
You don't want to do that.
Yeah.
Very expensive.
Time and money you don't need to spend.
How do you charge? How do you charge your clients?
I charge on a flat fee basis. So from beginning to end, you know what you're going to be paying. So for an individual, it begins and starts off at 4,000, and 95% of my clients are right there at 4,000. If you're a married couple, then it's 5,000. So, you know, the number of phone calls, the follow-up that needs to be done in terms of questions, it's, you know, my clients know what to expect.
Yeah. And do you handle other estate planning attorneys' documents if someone needs to come in to make a change?
Yes, so that happens actually quite a bit because they would have done a trust 20 years ago, and then now that attorney's retired or has moved out of state and doesn't practice anymore. So in that case, I will review it, but based on what the document says, I'll either recommend a restatement, which is just redoing the whole trust. You're just keeping the name of your original trust, or we'll do an amendment if it's simple enough and I feel comfortable with the quality of the work of that attorney.
Yeah, and the reason for that is because you're going to be held liable for the entire document if you make a change in that document.
That's right. Well, even reviewing it, I'm taking on liability,
Yeah,
right? Because I'm giving you legal advice and whatnot.
a
So
lot of liability in this field, in the estate
yes,
planning field.
yes,
You
yes.
know, you want it to go right.
Yeah.
What is your hourly rate, Julie, if you're practicing or doing something on an hourly basis?
It's $500. So if we did anything beyond the standard estate plan and you needed some, you know, like trust administration, you know, services in terms of, you know, because you've got your aunt who died and you need to act, then it's $500.
And when you do the set price, does that include transferring a real estate into the name of the trust?
Yes, it includes the transfer of one property. If you have additional properties, like, you know, 5 different rentals or even one other one, then that's charged additional. But in the beginning, you'll always know at the outset what you're going to be expected to pay before you agree, and we agree to proceed. There's
That
no
is an
surprises.
ethical, highly professional attorney,
Thank you.
which you are.
Thank
Thank you,
you.
Julie. Let's go into the program. We're going to talk about wills and trusts today. Last week, we talked about the durable power of attorney and the advanced healthcare directive. And then in the first session, we kind of did an overview. So today we're focusing on wills and trust. And what we're going to end up knowing at the end of the conversation is that a living trust for most of us in California is the way to go. Let's pull up your outline, Julie, and we'll get going.
Okay. Okay, so my PowerPoint. Okay, the other one just came up. All right, 1 second.
Yeah. Besides knowing the law, you got to know all these techie things.
I know. All right, everyone can see that.
Yep.
Perfect. So this is my contact information, but I'm sure it'll get posted in the chat later. So let me just proceed to the next. Do you want me to just take it away, Peter, or?
Yep.
All right.
Start in.
Okay. So what is the purpose of an estate plan? You're going to wonder, right? Is it just for the wealthy? You need to have a lot of money. And in the state of California, that is not the case. It is not just for those who have a lot of money, and it's not just for those who are elderly. Basically, if you're 18 and up, you need to have at a minimum the powers of attorney that you guys talked about last week. But overall, in terms of like the trust and the will, it's to create a plan to distribute all of your possessions, your assets. So you're making the decision as to how it is distributed and not the state or anybody else. And then it's also to plan for the care of minor children or individuals with special needs. So if you've got, you know, like this family right here, you've got minor kids here, you know, we're planning for something in this situation for a premature death, right? So it's something that's going to happen in the next 5-10 years. We all knew we're going to live until we're 95. We could all wait, but you need to make sure that you're planning for just the, you know, just in case, right? And how are your children going to be protected? Special needs are like special needs, you know, medical or, you know, physical, mental, those, if you've got children or beneficiaries with special needs, then we need to do some special planning for those individuals. And it's also planning for your disability. So while you're alive, but you're incapacitated, who's going to be handling your estate and your assets for you and for your benefit to make sure that you're properly cared for?
You
So
know,
that's,
for what I see happening today, this is number one, because they can keep you alive for quite a while. And dementia, Parkinson's, stroke, uh, who's going to be there to care for you? And and today, to get into another person's bank account or to handle the taxes or to pay the bills or to uh, keep the cable company going or the cell phone, it's all about having the legal authority to do so. And the living trust that we're going to talk about today is literally the best tool to do that, because it's quick, easy. You're going to find that out in a little bit. But planning for a disability and incapacity, gosh, that's number one as far as I'm concerned, as far as estate planning is concerned.
yep. And it's so critical to do that while you have capacity to make these plans in advance,
Yeah.
because the number of times I get phone calls saying, my mom's is no longer capable of doing things. I need to get a power of attorney. It's like, well, does she have any mental capacity to execute this document? It's like, no. It's like, well, then she can't sign it. You can't rightfully go and have her sign this because you need to have capacity to actually grant the authority to somebody. So make sure you get that done while you have capacity. Otherwise, it has to go to probate court, which we want to avoid.
Yeah, yeah. And the living trust is much more accepted than the durable power of attorney.
Yep, yep. I
So,
was going to just say that. Yeah, because even though it's amazing, you'll create, there are form powers of attorney on the website that you can find. It's completely compliant, let's say, with California laws, but the number of times that those documents or will get rejected by a financial institution, but a trust is, I never hear of trust being questioned.
no,
Yep,
it's accepted by most financial institutions.
yep,
I same here. I do this every day, and living trust never have a problem.
yep, yep,
Let's go to the next slide.
yep. Oh,
Oh,
so
we
avoiding
got to
probate, of
avoid
course.
probate.
Yes, yes. So wait a minute. I will go into what probate really is. So
Yeah.
for those of you who don't know. So what are the core documents of an estate plan? So when I prepare an estate plan for my clients, there are about like 7, 8 documents, but the 4 main ones that you need to have in place are these right here. So you've got the revocable trust, you have a pour over will, the financial power of attorney, and the advanced healthcare directive, which is for medical power of attorney. So the pour over will is a document that just says everything I own, I'm giving to the trust. So these are the 4 main documents, and I will get through it all. But now, what is probate? So the probate is a court process where the debts get paid and the assets are distributed. So if I was,
Title changes.
yep,
Title to your assets change hands.
yes, yes. So, but you've got, a judge who's sitting there who's going to be like, okay, what do you have? Or what did Julie own? What did Julie, well, who does she owe? What does she owe? And all of those things are distributed and paid out before any beneficiaries are paid, that's okay in and of itself, but it's the court process that you want to avoid.
Yeah. And
So
in a living trust, you just eliminate the court.
that's right, right. Because think of the trust as a company, right? So you set up a company and you're the CEO of the company while you're alive. And then you already have named your successor CEO, right? After I pass, my company will continue. This successor will just step in and continue.
Yeah.
So that's the way that the courts in this trust system that's been around even before, way back in England, even before America was formed, was the system understands that the trusts continue and it's a very smooth and seamless process. So does a will avoid probate? Because a lot of people will think like, well, I've got a will and that's enough, and it's going to say who's going to inherit from me. It's like, yes, it's correct, at least as long as it's not challenged and it's deemed valid. Whoever you listed as the beneficiary will get your assets after all the debts are paid. but it will still have to go through the probate process.
Does it have any power whatsoever during person's lifetime?
Of course not, right? So thank you for bringing that up. So when we're talking about disability, a will, it only comes into effect after you pass. A
Upon
trust
death.
is effective while you're alive and after you pass.
So
So,
we,
so if you're incapacitated, nothing is done. It's only just the distribution of what's going to happen after I pass.
yeah.
So
And it's, we consider it a kind of an emergency document practically.
Yes, exactly. It's like the bare minimum you should have, right? To make sure that, the charities you want, like the, Heart Association gets, $10,000 and whatever it is that you want to distribute it, that's the bare minimum. But otherwise, it's going to go into fall under the laws of intestacy, which is just the pecking order of who inherits and what order and what percentages that's dictated by the state.
So if you have assets titled in your own name, how much can you own?
To avoid probate, it has to be under $184,000 if it's cash and 500 if it's cash or a personal property. But if it's a real estate, then if it's over 61,500, then it will go get probated.
Yeah. It's called, yeah, we do a small estate affidavit for these kinds of assets. So please understand how you have title to your assets. Because if you have it in your own name, even if you're a dollar over 184,501 and you have it at a financial institution, they're going to demand a full-on probate.
That's right. Yeah. So, and the cost of probate is so expensive, which it'll come in, I think, in the next slide or so, but you want to avoid it. So basically the rule is if you own a home in the state of California, then you're going to want a trust. If you have bank accounts, that's as you said, Peter, over 184,500, and it doesn't have a beneficiary designation, it's in your own name, then you want to get that set up a trust. So why do I want to avoid probate? So first, it can be expensive. So attorney's fees and executor fees are based off the gross value of the estate. So if you've got a home that's worth $1 million and your equity, your down payment, let's say, was only 100,000 and you have a $900,000 loan, the probate fees are calculated off that $1 million, not your equity in it. And it's a very lengthy process. So it takes anywhere between 9 months to 2.5 years to probate your estate. So that's, so during that time, your assets are frozen. So if you've got minor children and they're going to, private school or preschool or doing different activities, you can't use that. The money in your estate can't be used to pay for those expenses or even paying for the mortgage until you get court approval.
Yeah, and this is really, the lengthy process really hurts you if you have a stroke or a heart attack or you have Alzheimer's and we need to get into your bank account to pay some of your bills. We're in the probate court, and the probate court is not quick, and it's very expensive.
Yes. And you also have no privacy. So what does that mean is, let's say you even had a will. All of that information, your will in terms of who you want your assets distributed to, everything that you own, what all your debts were, it is open to the public. It's public information and anybody can go and request information on what your estate size is. And then that opens it up to potential scammers, right? Or different creditors who are going to come out of the woodwork and make a claim on your estate saying, oh, well, so and so owed me money. So any interested party can come and see what you own. But I put interested in quotes because anybody can claim to be interested, right? And then this process, it invites disgruntled heirs to contest your will. It can expose your family to unscrupulous solicitors. So you're just kind of inviting more people and more problems into the settling of your estate. And then, of course, you've got no control because when you set up the trust, you have you have so much power within the trust to lay out the details and the method and the how and the amounts of of distribution to your beneficiaries that you can't do in a will. So the control is taken away when it's done under probate.
You know, which before we go go on, there is a myth out there that if you have a living trust, and you die, that within 3 months you'll get the assets. What is the approximate length of time for a trust administration?
Depending on the complexity of the assets, or or how the assets are sold, but
6 to 9 months?
Yeah, so to your point, it doesn't happen within the first 120 days. You have to actually wait. The trustee needs to wait 120 days, because when you have a beneficiary, or when there are beneficiaries in the trust, you have to give a copy of the trust to all the named beneficiaries as well as any blood relatives, and give them a copy of it, your immediate family, and give them a copy of them yet, and they have 120 days to contest the trust. So no distributions can be made during that time. But after that, typically about 6 to 9 months is a reasonable amount of time for things to get settled.
And here we have that exposure to multiple states for out-of-state property.
So yeah, so if I've got a home in California, but I've got a rental property in Florida, where I like to go vacation, then the Florida, you got to open up probate in Florida. So it's essentially twice the cost and and possible time too.
Yeah. Let's go to the next slide.
Yep. So how much is probate, right? How is it calculated? So let me just begin by saying that probate is one of two areas of law in the state of California where the legislature tells you how much an attorney can charge. So Pete, you had asked me earlier, how much do I charge? I charge 500, but that's because that's what I decided to charge per hour.
Yeah.
But if I was to do a probate and estate, I can't just charge $500. It's based on the size of the decedent's estate. So here, let's say you take $600, the fair market value of the home is $600,000. Then you take the value of any other property that you've got. So I kept my example pretty modest. So, bank accounts of $40,000, mutual funds in stock of $40,000, you've got a car for $15,000 and some jewelry. So your total estate size is, let's say, $700,000. So remember, I want to reiterate that on that $600,000, it's the selling price of your home. So 600,000, so all of that added up is 700. So now how do we calculate it? What does the state of California say I can charge? So you take the first 4% of the $100,000. So that's 4,000. Then the next $100,000 is you charge 3%. And whatever is remaining up to 800,000, you charge 2%. So in this case, because it's a $700,000 estate, we charge 2% on 500,000. I think, where did that go? Okay, so that's why it's 10,000 there. And then anything above the million, up to 9 million, is at 1%, just to give you what the statute says. So that's 0 in my case. And anything over 25 million is a reasonable amount. So in my case, it's 0, 0. So subtotal is $17,000. So you multiply that by 2 because both the executor and the attorney who's handling the probate are entitled to compensation. So that's $34,000 plus any approximate costs, like, how much the appraisal is going to cost, the cost of filing, and any other additional costs that the executor and the attorney will have. So let's just say it's 2,000. So total probate fees comes to $36,000 on a $700,000 estate. So compare that. So that $36,000 is taken out before any distributions are made to your beneficiaries. So I always ask, why pay that $36,000 when you can avoid not only, just the cost of it, but all of the other hassle and the lack of control and lack of privacy that we had talked about.
Yeah. If the same $600,000 for to do it under a living trust would cost you $10,000 or less. So just to give you an approximation.
Yes, yeah, it's really helpful to put that, give that perspective and comparison. So All right, so how do I avoid probate? Like we were talking about, you set up a revocable living trust. So what is a trust? So trust is, it's like a will, and it's a contract. It's a contract between the trustor, the trustee, well, between those two parties. So in my case, I'm the trustor because I'm making the trust, and I'm the trustee because during my lifetime, I'm the manager of my trust. And I
So,
determine, go
so
ahead.
I, the language, we
Hmm.
got legal language, it confuses people.
Yep.
Um, Trustor, settlor, grantor. Is there any different meaning between those?
No, they're all the same. They're all synonyms.
And they all mean the person who actually forms the trust or
That's
owns the property and puts it into the funds the trust.
right. So it's the one who makes the trust, right?
Yeah. And then you
Hmm.
have the trustee who is the manager of the assets because it's no longer their personal property. It's now a trust property.
That's right. So
And
it's
then
all
and then you got the trustee. Then you have an income beneficiary and you have a remainder beneficiary.
right.
And the income beneficiary, if it's your trust, Julie, you would be the settlor, grantor, trustor. You would be the trustee, and you would be your income beneficiary.
That's right. Right. So it's just as if, I owned it in my own name, right? So if I owned a bank account with $100,000 in it, it's in my name. I'm the owner and I can decide how to use that money, and I'm the beneficiary of that money, right? So it's the same thing with the trust, with the revocable trust is I'm the trustor, grantor, settlor. I'm the maker of the trust. I'm the manager of it. I can make decisions in terms of how I'm going to use this money during my lifetime to benefit me because I'm the beneficiary. The
Do people,
last, go
do
ahead.
people have to change their social security number?
No, not at all, because it still runs through you, your social security number, and all the tax returns, everything still remains the
Yeah,
same.
everything remains the same. It's
Yeah.
just, people think there's got to be something else complicated to it, and there isn't. You
Yes,
know,
the simplicity of it is really great, right? And
how is title if it's your trust, Julie, how would title read?
so my trust reads, the Julie Cho Family Trust is the name of my trust, but the title on my home will be Julie Cho as trustee of the Julie Cho Family Trust, dated whatever date it was.
And you should do that with your bank accounts, brokerage accounts, your real property. Should you put your car in entitled in the name of the trust?
No, you don't need to do the card. That's considered personal property, and personal property, it will be owned by your trust by another document that I have. It's called assignment of personal property, but you don't need to do the cards. But these are questions that a lot of my clients have at the end, right? They're like, well, what do I do now? And I love that they ask that, because if you don't fund it, if you don't ask those questions, then your trust is completely useless, right? So I help my clients with all of the funding. We go through all of the assets, and I tell them this account should be owned by the trust. This your retirement account it should add the trust as a contingent beneficiary, possibly. It really depends on the circumstances, but your home needs to be in the trust. And all the properties I get transferred for you. It's just the bank account. You need to go and do it on your own, but I give you very specific instructions on what to do with each asset. So it's very clear, and you have a good roadmap of what to do after.
Yeah. And the beauty of a trust is that if you become disabled or incapacitated for some reason, you are the trustee of your trust. And in your document, in the contract, it says, hey, if something happens to me or if I suffer from some sort of incapacity and there's a doctor's note, please only use one doctor. Uh, you know, uh, my successor trustee steps in
That's right.
and there's no change of, very little change has to happen.
Right. So the successor trustee just steps into your shoes, right, and handles these things for you. And I've got a client right now. He has full mental capacity, but he's just ill and he's in the hospital and he needs to get a property sold. So his successor trustee is going to step in because my client's going to resign as trustee and his successor trustee is going to step in and handle all of these affairs for him, pay his bills, get the house sold and things of that nature. And it's going to be seamless and smooth for him because you're just stepping to their shoes to do it. And to what you were saying earlier, Peter, is there's no issues with the trust. People will not contest the trust. The property is owned by the trust. We've got a certification of trust that says that, his successor trustee is now acting as trustee, and it's smooth and seamless.
Yeah. And when the person comes out of the hospital and gets better, he can assume the role again of being the trustee of his own trust.
That's right. That's right. Because it's revocable, so you can make any changes during your lifetime. So he's going to say, okay, I'm okay now. I don't need you to be my trustee anymore. And then he'll have that trustee resign.
Every transaction, financial transaction here in Orange County, all the institutions will require another person to have legal authority. And you have legal authority either through a living trust or a durable power of attorney, but you can't say, hey, I'm married to the person. That's not legal authority. Either you're on title or you're not. And so that's why these documents are so important for incapacity purposes, because it gives another person legal authority to handle all this stuff for you.
Yep. And that's why I said in the beginning, you need to have some sort of estate plan or planning done when you're 18, because parents think that, oh, my kid went to college and he's still my kid and I'm still paying for college. So I should be able to have any kind of access to, if he's in the hospital or, his financial accounts. But the day that they turn 18, you no longer have authority over them and you no longer have access to it. So you need to make sure that
especially the advanced healthcare directive, if they get sick in school, you need to help them out. You can't make decisions unless you have that legal authority to make decisions for them.
You can't even get information, right?
No.
Because of HIPAA. Yeah.
No. I'm the parent, and my son or daughter is 19. They don't know anything. Well, under the law, they're an adult.
That's right.
So let's go to the next slide.
Okay, so that's what the what is. So how do you do it? So
this
already
is huge.
This. So you transfer your assets from your name to the name of your trust, which you control as trustee. So the trust becomes the legal owner of all transfer property, which we've mentioned. And as trustee, you maintain full control over the trust assets, make any changes to the trust at any time before death, and buy and sell any asset or even cancel the trust. So just note here, it says make changes to the trust at any time before death, because after you pass, your trust becomes irrevocable and
or upon incapacity.
Yes. But nobody can make any changes in terms of how your assets are distributed after you pass. So it becomes an irrevocable trust at that point and upon your incapacity. But
yeah, and when your successor trustee has to step in, you don't have to change the tax ID number. You can get a new EIN number, but it's not a necessity. You can continue using the grantor's Social Security number.
Right. And then at death or incapacity, the assets stay in the trust and is managed by your successor trustee. And your trust can continue to provide for your loved ones and protect assets from creditors, divorce, and irresponsible spending. And this is upon your death, right? Well, even during your incapacity, your trust can continue to provide for both you and your loved ones. But after you pass, when your beneficiaries inherit the money from you, the trust, if you set it up properly, you can give your beneficiaries asset protection. So that means, if there's any creditors after them or any kind of divorce proceedings that's pending, or, going to be happening in the near future, whatever inheritance you give to your beneficiary will be protected for that beneficiary's benefit only.
Okay, now
and of course, irresponsible spending. Sorry?
Can somebody get asset protection with their own living trust?
No, so it's a revocable trust during your lifetime and when you've got capacity, and during that time, you do not have asset protection. It's only the irrevocable trust that gives the beneficiary the asset protection.
Yeah. And be really leery of, I see ads all over the place of I think unscrupulous attorneys who advertise asset protection. And it's, you can't get asset protection in California for your own debts. You can delay it and maybe make it more difficult, but they're certainly not 100%. Um, you know, in a living trust, we have the name of the trust. And why do you give a little family history in the beginning of your trust documents?
Right, so you'll say, I'm married and I've got two children. The reason why you do that is because that's identifying who your families and who the potential beneficiaries are. And so that nobody else comes out of the woodwork claiming that they're a child of mine, or some family member who's entitled to any kind of benefit. So you need to
Or
give
who
the background.
should married couples have one trust?
That it depends, right? So you've got the blended families, right? If it's a subsequent divorce or subsequent marriage, and they had a prior relationship and children from that prior relationship, you should it depends on how you perceive your assets and how your assets are being handled in that marriage.
Yeah,
Um,
but you probably should state in that kind of family history in the front, I've been married twice and, whatever it
yeah,
is, or
right,
so that everybody knows the situation. What
right.
if I want to disinherit a child? Should that be mentioned in there?
Yes, absolutely. Right. You want to mention that because if I've got three children, I want to disinherit my youngest, and I don't specify that, but I only provide for my first two, then the youngest can come and say, well, it was just neglected, or she forgot to put me in there. But so if you want to specifically disinherit someone, you need to name that person. Even
Yeah.
if it's not children, if it's blood relatives, like a sibling or whatnot, they could be potentially contingent beneficiaries, like if your entire family, went down in the Titanic. So if there's like a sibling that you want to disinherit, I suggest that you do that as well.
Yeah. Um, then we have this entire section on the successor trustees.
Mhm.
How many successor trustees should a person name?
I recommend at least two, right? So, and they can be co-trustees, but you want to name at least two people because you don't, what happens if you only name one person and that person is not able to do it when you need them to, 10 years down the road? You don't want to have to go through amending the trust or just not having nobody, because if nobody's named, then they've got to go to probate court to get somebody named as a trustee. So at least name
That's what
two.
you want to avoid,
Yeah.
the probate court.
Yeah.
Does the successor trustee have the power to appoint a successor trustee?
If the trust says they can, it has to be, but that kind of authority needs to be laid out in the document, and depending on what your desires are. But a lot of times I think it makes sense to say the successor trustee I named can appoint another successor, because otherwise it's going to go to probate again, right?
Yeah, one of the things that people don't realize is that this is a contract, and whoever is the trustee has to follow the terms of that contract and can only do what it states in the contract that it can do. And you
Right.
can make it very specific as to what you want with your legal counsel. It's very flexible, but let's say, but if you don't have that power to appoint in there, it can't happen. You got to go back to the probate court.
Right.
What about people name older individuals? probably not a good idea.
No. So yeah, you don't want to, if you're 60 years old, you don't want to name your brother who's 70 years old, right?
Yeah.
And I always tell them, say being a trustee is not an honor, right? It's an honor to be named because you've been trusted to do this for them, but it's a lot of work. So make sure the person you consider as naming as a successor trustee is first they know that you want them to do it and willing to do it when you ask them, and also that they've got the capacity to do it. Like
And
time.
what do you mean by capacity? Do you have to be 18 and breathing? Is that basically it?
Well, you do have to be an adult, but I don't recommend an 18-year-old, right? So capacity meaning the financial, the organizational skills to do it, the financial savvy to do it.
Yeah.
Just like executive function, right? To
Yeah.
know who to go to ask for questions, that
How
kind of
about
thing.
naming one of your children who's out of state?
It's okay to be out of state, right? But the child should be of a proper age and at a life stage where they can do it, right?
But
If they're
remember, if you name it out of state, it's a little difficult. Real estate, financial institutions want
Yeah,
to see your driver's license, and it makes it very difficult if you're out of state. How about foreign? I have a son or a daughter who lives in Germany or Brazil or another
yeah.
country.
No, you
Can a
cannot.
foreign citizen be a
No,
trustee?
no, you can even be a U.S. citizen, but if you're living in overseas, you cannot be. That's called a foreign trustee, and there's very, very bad tax consequences of having a foreign trustee. So you don't want that.
Okay. Once we get past the trustee stage in a living trust, then we go through powers. What does that mean in a document? And pretty much that's boilerplate. But why is it that important?
If that power is not set out in the document, the trustee can't do it. So just like we were saying in terms of whether the successor trustee can name another successor, if that power and authority is not in the document, he can't do it or she can't do it. So
So the
you
powers would be able to sell property, be able to manage stocks and bonds.
right,
I think it takes probably a good 15, 20 pages of your trust as to powers.
right, right. So like
And
you
they're
said,
important,
yes,
but
of course.
one of the powers I never, well, once in a great while I see it is the power to make gifts to children.
Yes, yes. So what that means is if I'm alive and I'm incapacitated and my successor trustee if I give the successor trustee the authority to make gifts, it's if I was, then the trustee is going to go back and look at what the gifts I've been giving to different people for their birthdays or Christmas, or the recipient can come to the trustee and say, Julie's been giving me gifts of this and that, regularly. Can we get that same gift? And if the power to gift is in my trust, then the successor trustee can do it. But
Yeah,
again, if it's not laid out, they can't do it. But
can't do it.
the boilerplate basic things are like selling real estate, dealing with the life insurance, retirement accounts, things like that.
Yeah. Then we get to the distribution stage in your trust, and that's unique to everyone.
That's right.
Uh,
Yeah.
would you recommend leaving assets in percentages or specific dollar amounts?
You need to have at least a percentage because you never know what that dollar amount is going to be. So, I've got a client where they want to give a certain amount to, let's say, a charity. I say, well, think of either a percentage like 10% or no more than blank or no less than whatever. So you give a guide to the trustee as to what that dollar amount was that you were thinking of. But you don't want to do it like $100,000 because what if you live till 95 and use up all the assets and there's nothing to give to your children? So
Yeah.
percentages are generally better.
Better percentages are better. And then you get into whether or not somebody can handle the money, whether somebody has a special need, when somebody needs creditor protection.
Right.
All of that comes in that distribution section of the trust, and that's unique to all of us.
That's right.
Depending on our family situation, etc. Whether assets are separate property or community property is also a big issue as to how it gets distributed.
Right, right.
You
So
know,
to
so
answer your earlier question about a married couple, yeah, most married couples do have one trust, but within that one trust, you can specify what's separate property and what's community, and the amount of detail of that you can put into trust is really it's limitless. You don't want to control too much from the grave, but you want to be able to lay out what your family situation is and what your values are so that that distribution is really reflective of what your desires are.
what about creditors? When after you die, how are creditors involved, and does the trustee have to pay all the creditors?
Yes, all of my creditors, if I'm the one to die, my creditors and my debts, the valid ones, right? They all need to be paid first because that's what I owed and therefore my estate owes it. So the process is basically the trustee gathers all of my assets together, sees what my net worth was at the time, and then determines what all my who I owed money to. So, my mortgage will get paid first, my car payments will get paid, my credit card debt will, payments that were due for
Taxes
them.
will be paid.
Yeah, all of that, yes, in taxes, all of that is paid. And then after those things are handled, then that's when my beneficiaries will get their
Who's
distribution.
going to be liable if those aren't paid?
Well, the fiduciary, so the
The
trustee,
trustee.
yeah, the trustee has what's called a fiduciary duty in the state of California. It's a legal duty to not only follow through on my instructions on the debts, but to follow through on the instructions of distribution to my beneficiaries. But they have a responsibility to collect my assets and pay the debt. So that lies on with the trustees. So that's also why that you're not going to get your money, your inheritance immediately because the trustee has to handle all of these other financial and fiduciary issues first.
And the fiduciary liability is there whether you do a friend, whether you do a family member, you hire a professional, it doesn't matter. That fiduciary liability is there, and it's a much higher than normal, let's say, negligence duty or normal liability.
That's right.
You
Yeah.
you got to do what's in the person's best interest.
Yeah.
So in picking a trustee, make sure that they get along with the rest of the kids and
Yep.
they're somewhat competent.
Mhm.
Um, let's see. There was a question about grandkids.
Yes.
How should grandkids be handled when you're making a distribution?
I mean, it's if you want to provide for them, we can provide for them, right? There's really no one
Well, they're
set
under
rule.
18. Can they have title to
Oh,
assets?
yes. I mean, yes. If I'm assuming that they're over 18, but if they're under 18 and they're minors, then there's you don't trust the parent, then you want to give it specifically to the grandparent, to the grandchild, then we'll provide for them, but we'll create a sub trust for them where they can then get and put in there that they can get the money or the principal or the income upon certain ages. So it will be held in its trust for them until that age of distribution that you designate for them.
Yeah. My mother-in-law had approximate estate value of around 400,000, and she had a condo and some other assets, but she wanted to make sure that the grandkids got something. So what she did was she had three daughters, and she told each daughter in precatory or wishful language in the trust, I wish for you to give 10% of whatever I have given you to your children. And but it's up to you to make that gift.
Right.
And the issue there is that you just don't know on young grandkids whether they're going to be an alcoholic, a druggie, or irresponsible, etc. And you leave that responsibility to your children to give to the grandkids. And the grandkids now know that they were thought of in the trust.
Right.
It's
So if
another
you
way of doing it.
Yeah, that is. So if you trust your children and it's up to them to decide how much to give to your grandchild, that's one way to do it, right? So it really just depends on the family dynamics, but that simplifies it certainly, right?
Yeah.
But
And
and
remember, most of the cases that go to court is because families do not get along.
right, right. So, if you want to avoid that kind of, it's up to you, then just lay it out exactly how you want it to be done.
Yeah.
And also in that situation, if it's 400,000, then it's not a tremendous amount of money that would be going to a grandchild. But when the direct child is giving money to somebody else, that it has to be within that gift tax amount. Otherwise, you have to file a gift tax return because that's essentially a gift that you're giving. So, if I'm the child and I get an inheritance from my mom, and then she's telling me to give some to my kids, so I wish you'll give some to them, and I give each of my child $20,000, then that's giving $2,000 over the gift tax amount. So you need to be mindful of that. So depends on just how much we're thinking and we're talking about, and based on that amount, we can come up with the appropriate way to distribute to the grandkids.
So I mentioned 300,000 or 400,000 from my mother-in-law, but that gets us right into this slide. Who needs a trust?
So homeowners, right? So if you've got a home, it's going to get probated if you don't have it in a trust. So that limit of 61,500, I don't think any of our listeners here who are homeowners have a home that's valued at that amount, or even $100,000. So
Yes.
if you own a home, put it in a trust so it doesn't get probated. And home probate sales are the worst, is what I've heard from real estate agents. So basically, that's if you have to probate sale a home, your executor and your attorney has to go to court and say, well, we want to sell this house. This is what the appraisal is. And you have to get the judge to approve that, and then approve the sale of who the potential buyer is going to be. And that's just a lot of lost time. And real estate is so, up and down, or going up most of the time, that you don't want. Time is really money in real estate. So you want to avoid a probate sale on a home. And then, of course, if you've got other assets over 184,500, you want to have a trust set up.
Yeah.
And so
Well, you know,
this includes business interests too.
yeah. Who needs a trust? We mentioned before, if you have property outside of the state,
Right.
that's
Yes,
almost
that
a
too.
slam dunk. You need a trust.
Absolutely. Right.
From my point of view, too, is that if you're single, if you're single and you don't have anyone who can make decisions for you, that even if you were the smoothest, loveliest person in the world, they're just not going to listen to you or to your friend or your partner, or etc., unless you have a trust and
Yes.
you've named them as a successor trustee.
Yep.
So
great point.
And if you have a substantial estate, I mean, a trust is just a basic tool.
Yes. Yep. So, and then some special estate planning considerations that we had mentioned earlier are special needs. So if you've got a child with autism, let's say, and is not very high functioning, and so is, he or she's going to be on government aid, then you want to make sure that the inheritance that is going to go to your child does not go in their name, because most of the government aid is based on income and asset qualification. So if my child with autism is going to inherit even $100,000 from me, goes into his name, then he's going to now no longer qualify for government aid. Then he has to spend down that money and then reapply for government aid to after the money is gone, saying now I qualify based on income and assets. But a lot of the children who have special needs, or beneficiaries who have special needs, they're not able to go through that process and spend down money. It's just unnecessary process that you can avoid by setting up a special needs trust or having the money go into a special needs trust.
And special needs is to allow the individual to continue on their government benefits seamlessly.
That's right.
And yeah, because to requalify is just an enormous effort.
Yes.
And you're in line, and it takes a lot of time to do so.
Yeah, and Yeah, and sometimes there's like a waiting period too,
Yeah.
after you've got to wait a certain number of years or months. So you don't want that break in government benefit to happen.
And just by the definition of it being special, whoever you named as a trustee for your special needs trust, make sure that they have the time, the energy, and the desire to be the trustee.
Right.
What I find is they name a family member and then they find out how difficult it is, and then they want to get out. Well, a lot of attorneys out there have recommended a very low they uh, amount go to your special needs trust. And there's no way you're going to be able to hire a professional if your special needs trust only has a couple of $100,000 in there. So recommend at least $500,000 or more, so that in the event a family member gets tired or doesn't want to be involved, that there's a professional out there that will take over the job.
Right. And because special needs trust administering those there's different legal requirements too. So you want to get someone who is very familiar with that, so that it's
Sometimes
not.
the beneficiary is not very compliant. They're special. Divorced individuals.
Yes. So those people you really need to have an estate plan in place because let's say you've got minor children and your ex-husband or is certainly going to be the guardian of the minor children, but I wouldn't necessarily want him to be the one who's holding the purse or determining how much is needed for my children because you never know if it's going to be appropriately spent. So divorced individuals absolutely should consider getting a trust set up. And then also make sure that if you are divorced, that you have updated your beneficiaries on your different accounts. So many times I come across divorced individuals who have their retirement plan and it still names their ex-spouse. And they just don't think of doing that. And understandably, that they went through a lot of things, and that's might be the last thing they thought of. But you need to have an estate plan set up and make sure your accounts are properly naming the beneficiaries you want. And then we had talked about blended families. So blended families are really interesting. So that's, think of the Brady Bunch, right? Mike and Carol, right? They've got children from prior relationships and then they got married and they're a great family, right? They're so happy, they're loving, they all love the 6 children equally as their own. So it's beautiful. But let's say that Mike dies, and everything being owned, jointly. So Mike dies. So while Carol's living, it's not necessarily a problem because she still has control over the assets. It all went to her. Now she's using the money to take care of all 6 children. But if she was to die without a trust in place, what's going to happen to Mike's kids? Those 3 boys, they don't get anything because it's going to go according to Carol's children. So her 3 girls are the only ones who are by law allowed to get money, and according to the laws of intestacy that I mentioned. So Mike, by dying first without an estate plan in place, unintentionally disinherited his own 3 children. So blended families, you really want to do that. Get that plan in place. And then if there's any separate property, you want to make sure that that's parsed out and it's kept separate as opposed to it being deemed community property. So go ahead, my Peter. You had something to add. I could see the wheels turning.
Well, the thing of it is that when you talk about blended families and people, the most common form of ownership is joint tenancy with right or survivorship.
Yeah.
And for married couples, a lot of times parents put their child on a title thinking that, hey, this is the way to avoid probate. I don't know if this is the place to talk about joint tenancy, but I would like for you to spend a little bit of time on that. The traps that are involved in joint tenancy.
Right. So joint tenancy is basically saying between, the 2 joint owners, the survivor takes all, right? So if husband and wife, they've been married, like Mike and Carol, they buy a house together in joint tenancy. Then if Mike dies, then Carol's gonna get 100% of it. So it's the pitfalls of that is maybe you don't want it to go 50-50, or you don't want it to go 100%. You want it to go 50-50. So a lot of blended families, let's say, some you're in your 50s and you get married, and husband and wife each bringing 50% into the down payment, but they want their 50% if they were to pass to go to their own respective children, then you shouldn't do it in joint tenancy because you want it to be separated out. So in that case, the appropriate ownership is tenants in common. And that's saying it's a divisible interest, right? 50% after it's sold and whatnot. But the problem with the problem that people have when they're buying property and taking title is that the real estate agent and the escrow company, they can't give you legal advice on how to take title. So the knee-jerk reaction and fallback that people go to is the joint tenancy, and without explaining to them what the implications of that are. So don't just automatically add a child or add a spouse, or buy property together in joint tenancy without really understanding the implications and
so you have joint tenancy with right of survivorship, and that means too, upon the first death, technically, you're only going to get 50% of a step up in basis.
Yes, yeah. I mean, that's a tax issue, right? So
yeah. So if you bought your house for 100,000 and it's now worth $1 million, you only get a step up to 500,000 with some other rules in there. But you want the full step up so that you don't have to pay any tax when you sell the house to the surviving spouse. And joint tenancy could be a trap there.
Yeah.
There's another way to hold title called community property with right of survivorship. What does that mean?
So that's just when husband and wife buy it together, then it will say, or it could say, husband and wife as community property with right of survivorship. So that just means that you're owning it as community property, meaning 50-50 between the husband and wife, because California is a community property state. So it's saying it's a 50-50 interest, but then when you say right of survivorship, you're saying, well, the surviving spouse can then take it all. So it's like joint tenancy. So, but if it doesn't have the language right of survivorship and it does husband and wife as community property, then that means it's 50-50 and it's separate. And
another way to hold title is tenants in common. What does that mean?
So that's like the 50-50 split of the husband and wife as community property. So tenants in common is saying we each own our 50% share, and then we can dictate how much of that 50%.
It doesn't automatically go to the survivor.
That's right. It doesn't go. It's yours, and it flows down according to the inheritance laws or what your trust says. So remember, it has to be owned by the trust.
Yeah, and you can then own property in your own name, but then when you die, you go through probate.
Yeah.
Okay.
So I had a situation with husband and wife. They owned, the title said husband and wife as community property and didn't have the right of survivorship in there. So after wife died, the husband wanted to sell the home, and he was shocked to find out that he couldn't sell it, and he had to probate her 50% of community property and get that probated before he could even sell the home.
It's so community property with right of survivorship. Then we're not going to go into every which way to hold title, but the best way to hold title is in a living trust. Living trust is a way to hold title to your assets.
Right. So it will say, John and Jane as co-trustees of the John and Jane Family Trust, and that's how it's held in title. And then therefore, what's going to happen with that home and the proceeds of that home will be controlled by your trust document.
Right. And that's the way you want it.
Absolutely. So, then there's no issues of, joint tenancy, tenants in common. There's none of that comes up. And obviously you're avoiding probate too.
Yeah. Medi-Cal, we're not going to go spend too much, but upon your death, the state needs to be paid back.
Right. So if, you can own a home and still qualify for Medi-Cal if you don't have the right income, right? So, but
It's
what can
income
happen,
based today.
sorry?
Medi-Cal is income based today. It's
Right,
not
right.
on assets owned any longer.
Right. So that's why, but even before when it was actually asset-based, you were still allowed to own a home because the state of California recognized that you're entitled to have a place to live in. But if you own a home and that home is in your name, so not in the trust, so it's owned in your name and you get Medi-Cal benefits and then you pass and, no spouse is living there in the home or no disabled child is living there, then Medi-Cal has a right to come back and get reimbursed on all of the Medi-Cal benefits that they paid out to you during your lifetime. And that reimbursement will come out of the value of the home, of the sale proceeds.
Yes.
So,
If-
but the way that you can avoid the payback so that all of the sale proceeds go to your beneficiaries is by putting it into a revocable trust.
Yeah. Lots of scams out there involving planning for Medi-Cal. Make sure you see a qualified, ethical attorney if you're in a situation that you're dealing with Medi-Cal planning.
Right.
Let's go to the next slide.
Yep. So some of you who are on this today already have a trust. So if the question is, what if I already have one? Then what are some of the considerations you should have in mind is, have you or your beneficiaries had a major life change, right? So maybe your children are the beneficiaries and one of them is in the middle of a divorce, or maybe one got married and you just love the new in-law, or maybe they've had children. So any kind of, or there's been a death, right? Or with their named trustee, or even any of your beneficiaries. If there's any of those kind of life changes, then consider having a trust review done to make sure that it says exactly what you want and the distribution. And then consider it also the asset protection for your beneficiaries. So a lot of the trusts, those simple trusts that maybe paralegals prepare because paralegals can't give legal advice, or CPAs even, these non-attorneys will prepare trusts for people and charge a very nominal fee. And the trustor will think, well, I just paid, $1,000 for it. I've got a trust and I'm good. But the problem with those is it doesn't think about who your beneficiaries are, what their life stage is, and how it should be distributed. So if you've got, $1 million and your beneficiaries, assuming they're all adults, they're 18 and 22 and they're going to be getting $500,000, it might not be the best thing to do that. Or if you've got, a larger estate and your very successful child is already, established and don't need an inheritance necessarily, but they're going to come into 2 million from you. They don't need that extra 2 million going into their name. You can set that aside to give them, protect that 2 million for them.
Lots of good planning. But I think this is your second point. If married, do you currently have an AB trust?
Right.
If you currently have an AB trust, which basically means that upon the first death with a married couple, the estate splits into two different trusts. And the language that is used in the trust at the time when you did the AB trust, it says shall, must. The trustee sometimes doesn't have a choice. And it was done for tax purposes. Well, today, the tax is 13 million plus per individual. So an AB trust today may not be a necessity for tax purposes, but may be a necessity for other purposes. So if you have one, really go see an attorney and talk a little bit about it. Let's go to the next slide.
That's it.
Good.